You are about to fail a test, and you haven't even been charged with anything yet. The officer is going to ask you to follow a pin with your eyes, walk a straight line, and stand on one leg. And the moment you say yes, every stumble, every sway, every blink that does not fit his checklist becomes evidence in his report. He will score it. He will document it. And none of what he writes down has to reflect whether you were actually impaired. It only has to reflect whether you performed to his standard, in the dark, on the side of a road, while your heart is pounding and his lights are in your face. I have spent years going through body cam footage, DWI arrest records, and suppression hearing transcripts. And the pattern is the same every time. Drivers who get arrested after a cognitive driving assessment did not fail because they were drunk. They failed because they did not know that participation was voluntary. Here is what most drivers do not know walking into this moment. When a law enforcement officer asks you to perform a driving cognitive assessment, or what most people call field sobriety tests, he is not administering a neutral, scientific exam with your well-being in mind. He is constructing probable cause. These tests were not designed to determine whether you are safe to drive. They were designed to generate observable data points that justify an arrest. That distinction matters enormously, and it is the one thing the officer is counting on you not knowing. The three standardized tests, the horizontal gaze nystagmus, the walk and turn, and the one-leg stand, have a combined list of specific clues that an officer is trained to watch for. Not general signs of impairment. Specific clues. If you start walking before the instructions are finished, that is a clue. If you raise your arms more than 6 inches for balance, that is a clue. If you take 9 steps instead of 10, that is a clue. You can be completely sober and accumulate enough clues to justify an arrest, because these tests are graded on precision under conditions no one performs well in: side of a highway, headlights, adrenaline, an armed officer watching your every movement. The test is not designed for you to pass. It is designed for you to provide material. Now here is the piece of law that changes everything, and it is the one courts have been clear about for decades. Field sobriety tests are voluntary in all 50 states. There is no statute that requires you to perform them. There is no law that penalizes you for declining. A refusal to perform a cognitive driving assessment is not the same as a refusal to submit to a chemical test. Those are legally distinct categories. The officer is not required to tell you that participation is optional. In fact, the way these requests are worded, step out of the vehicle, I'm going to have you do a few tests, is deliberately framed as a command, not a choice, because compliance rates are significantly higher when drivers believe they have no alternative. You have an alternative. You have always had an alternative. And once you understand the legal architecture behind that, the correct response at the moment testing is mentioned becomes straightforward. Here is what the courts have said, and this is what the officer is counting on never reaching your ears. In City of Seattle versus Stallsbroten, the Washington Supreme Court held that field sobriety tests constitute a search and are protected under the state constitution. In State versus Ferrier, courts have addressed the coercive framing used by officers during consent-based requests. In Berkmare v. McCarty, the U.S. Supreme Court acknowledged the inherently coercive nature of roadside traffic stops. Multiple federal circuit courts have held that a refusal to perform field sobriety tests cannot, standing alone, establish probable cause for a DWI arrest. The smell of something in your car, the fact that it was late, the assertion that your eyes looked glassy, none of those individual factors, and none of them combined with a test refusal, automatically constitute the independent, articulable, specific reasonable suspicion required to escalate a stop into an arrest. The officer needs your performance. He needs clues on a checklist. He needs your body to give him what the evidence cannot. And you have the constitutional right to decline. So here are the exact words. The moment the officer says anything about a cognitive assessment, field sobriety tests, or any roadside evaluation, you respond calmly and clearly. Officer, I respectfully decline to perform any field sobriety tests. I am exercising my constitutional right to refuse. Am I free to go, or am I being detained? Say it once. Say it politely. And then stop. Here is why every piece of that response is doing legal work. I respectfully decline to perform any field sobriety tests. This closes the door on the entire evidentiary sequence before a single clue is recorded. No stumble. No sway. No failure to maintain a fixed gaze position. Nothing goes in the report because nothing was performed. The word respectfully matters because it takes away the narrative that you were combative or uncooperative. That narrative is worth more to a prosecutor than you realize, and declining politely strips it away entirely. I am exercising my constitutional right to refuse. This language signals to a watching body cam, and eventually to a court, that your refusal was knowing, voluntary, and legally informed. You are not confused. You are not impaired. You are making a legal decision with full awareness. That distinction is powerful. Am I free to go, or am I being detained? This question forces a legal fork on camera. The officer must now commit to a position. Either he lets you leave, in which case the encounter ends, or he tells you that you are being detained, at which point he is legally obligated to articulate specific, independent, articulable reasonable suspicion that goes beyond the testing request he just made. He cannot detain you solely because you declined to perform voluntary tests. The law does not permit it. That question shifts the burden back to him in the most legally efficient way possible. Now the officer is going to push back. Every officer does, because the decline is unexpected and the pushback is trained. Know what is coming so none of it surprises you. If the officer says, if you have nothing to hide, just do the tests and we'll get you on your way. That is a consent manipulation tactic, not a legal obligation. Your response. Officer, I once again respectfully decline any field sobriety testing, and I will not answer further questions without my attorney present. Calm. Same tone. Same delivery. If he says, refusing the tests is just going to make this worse for you, that framing is designed to create the impression that refusal is legally consequential. It is not. Your response does not change. If the officer at that point orders you out of the vehicle, understand what the law says. Under Pennsylvania versus Mims, a law enforcement officer can require you to exit your vehicle during a lawful traffic stop. That is settled law. Comply with the exit order. Exiting the vehicle is not consent to testing. The moment testing is mentioned again, your response is identical. Officer, I respectfully decline to perform any field sobriety tests. If the officer places you under arrest following your refusal, the only words that come out of your mouth after handcuffs are on are these four. I want an attorney. Under the Sixth Amendment, that invocation terminates all interrogation. Everything that happens from that moment goes through your lawyer. Do not explain. Do not justify your refusal. Do not try to talk your way back from the moment. You have said exactly what the law requires you to say. There is one layer that most people underestimate, and it is the one that determines whether any of this survives contact with a jury. The body cam captures everything. It captures your voice, your posture, the way you hold eye contact, whether you are trembling or steady, whether your words come out clear or halting. And if this case ever goes to a courtroom, 12 strangers are going to watch that footage and form an impression of you before your attorney says a word. The drivers who protect themselves most effectively are not cold, not robotic, not aggressive. They are calm, deliberate, and decent. You can exercise every constitutional right you have while being a completely respectful human being on camera. In fact, that combination, polite, informed, precise, is the most powerful version of this response. It gives the officer nothing to build with and gives a future jury nothing to hold against you. Rudeness on a traffic stop does not stay on the traffic stop. It follows you into a courtroom. Stay clean. Stay calm. Stay on record. Memorize these before you close this video. When the officer requests a cognitive driving assessment or any field sobriety testing, Officer, I respectfully decline to perform any field sobriety tests. I am exercising my constitutional right to refuse. Am I free to go, or am I being detained? If he pushes, Officer, I once again respectfully decline any field sobriety testing, and I will not answer further questions without my attorney present. If he orders you out of the vehicle, comply with the exit, then repeat your refusal if testing is raised again. If you are placed under arrest, I want an attorney. For positions, all of them grounded in constitutional law and case precedent. None of them require arguing. None of them require hostility. All of them work because they are specific, they are on record, and they give the officer no evidentiary material to document. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances. If this video reached you before you ever had to face that request, it did exactly what it was built to do. Subscribe to this channel right now, because knowing your rights in one scenario and being blindsided in the next one is how good people end up in courtrooms they never expected to see. Every video on this channel is built around one scenario, one legal framework, one set of exact words, so that when the moment arrives, there is no hesitation, no guessing, and nothing left to chance. Subscribe. Share this with someone you drive with. Someone watching this tonight might be facing that cognitive assessment request tomorrow morning, and what they say in the next 30 seconds will determine what happens next. Make sure they know their rights, how to use them, and how to walk away protected. Stay calm, stay protected, stay free.